Time and time again, I hear the argument and read in the comments that the police cannot ask for your name or your address when out in public. Now, I'm about to disappoint some of you because there is a standard situation and then a special situation. So welcome back, I'm the Black Belt Barrister helping you to understand law. So the basic and standard situation is as follows. If you are stopped by the police out in public for any reason whatsoever and they ask you questions, ordinarily, the basic position is you do not have to answer those questions. Unless, of course, you are being detained, you are under arrest, you are under caution, and even then you still don't have to answer the questions, but as they say, it may harm your defence if you do not mention when questioned, something that you later rely on in court. Although, as I say, you don't have to say anything, as the caution goes. But there is one very special situation where if you refuse or you fail or you were still give fake details to the police as to your name and your address, you will be committing an offence. That is thanks to Section 50 of the Police Reform Act of 2002. Because it provides that a constable in uniform, mind, if they have reason to believe that a person, you, has or is engaging in anti-social behaviour, which I'll come back to in a moment, he, the constable, may require that that person, you, give his name and address to that constable. Now, antisocial behaviour within this part of the Act has the meaning as defined by Section 2 of the Anti-social Behaviour, Crime and Policing Act of 2014. And so looking at the Anti-social Behaviour, Crime and Policing Act of 2014, the meaning of antisocial behaviour is, in this part, as defined by Section 2, subsection 1, A, that the conduct is such that has caused or is likely to cause harassment, alarm or distress to any person. And this is a rather subjective test. And B, and this might broaden things up a little bit, any conduct that is capable of causing nuisance or annoyance to a person in relation to that person's occupation of residential premises, i.e. if you are standing outside somebody's residential premises causing them nuisance or annoyance deliberately, this is then likely to be considered antisocial behaviour as well. And perhaps the direct alternative to this is conduct that is capable of causing housing-related nuisance or annoyance to vaguely any person. So going back to the Police Reform Act, if you've done any of those things that could have caused or is likely to cause harassment, alarm or distress to any person, or conduct that is capable of causing nuisance or annoyance to any person in relation to that person's occupation of a residential premises, then the police can indeed demand to know your name and address. And under subsection 2 of Section 50 of the Police Reform Act 2002, any person that fails to give his name and address when required to do so, or gives a false or inaccurate name or address in response to a requirement under that subsection, is guilty of an offence and shall be liable on summary conviction, so it's a summary only offence, to a fine not exceeding level 3 on the standard scale, which in English presently is £1,000. So £1,000 as a fine for the refusal to provide your name or address, or probably worse still, to give a false name and address to a constable when the constable has reason to believe that you or any person has engaged or is engaging in antisocial behaviour. Now, when we want to know what intentional harassment, alarm or distress means, we can look to various other bits of legislation. For example, the Criminal Justice and Public Order Act of 1994, which sets out that intentional harassment, alarm or distress is, for example, where a person uses threatening, abusive or insulting words or behaviour, or disorderly behaviour, or displays anything in writing, a sign or other visible representation which is threatening, abusive or insulting, thereby causing that other person harassment, alarm or distress. So whilst at the moment there is a lot of talk of free speech or freedom of expression and Article 10 of the European Convention on Human Rights, which is the freedom of expression, it doesn't necessarily mean you can just go around shouting and saying whatever you want to whomever you wish. Because if you say certain things that are going to cause harassment, alarm or distress to another person, then not only will the Protection from Harassment Act of 1997, which does require a course of conduct, which is at least 2 occasions, but also the public order offences, such as those in the Public Order Act of 1986, inserted to some degree by the Criminal Justice and Public Order Act of 1994. which is not just conduct which is likely to cause harassment, alarm or distress, but also that is likely to cause fear of or to provoke immediate violence. However, there is a defence in this act where the accused could possibly demonstrate that their conduct was reasonable, which must be interpreted in accordance with the freedom of expression, for one thing, and other freedoms. However, where these freedoms are engaged, and this is part of the conversation of late, where these freedoms of expression are engaged, there must be justification for interference of that right to the freedom of expression, for one thing, and a prosecution may only proceed where it's necessary and proportionate, which in some cases just recently have obviously deemed to be necessary and proportionate. So the next time the discussion comes up as to whether or not the police can demand your name and address, you will hopefully refer to this video, share this video with them, and settle the discussion. I hope you found that interesting and useful. Please like the video and subscribe, as I always try to bring you useful legal guidance. But remember, always seek formal legal advice. But in the meantime, thank you so much for watching.